Between late 2020 and early 2021, the FBI conducted over 278,000 searches on American citizens. Every one of these queries was performed without a warrant. Analysts searched the names of political campaign donors and journalists. In one case, an FBI analyst queried the names of individuals they had met on a dating app. During the civil unrest of 2020, the Bureau also used the system to query domestic protesters, moving past the program's intended focus on foreign threats. A tool designed for foreign intelligence has been adopted as a domestic search engine, allowing the government to browse the private lives of Americans. Congress enacted FISA Section 702 as an emergency measure following the September 11 attacks. The goal was specific: provide the intelligence community with the tools to monitor foreign terrorists and spies located overseas. But digital communications are interconnected. When a foreign target emails or texts someone inside the US, that American's data is incidentally swept up alongside the target's. Instead of discarding this domestic data, the government retains it in massive, searchable repositories. This side effect of global surveillance created a vast digital archive of American communications, accessible to intelligence agencies without the standard requirements of a criminal investigation. The Fourth Amendment generally requires the government to demonstrate probable cause to a judge before searching a citizen's private records. Analysts bypass this step through what is known as the backdoor search loophole. Because the data has already been collected under a foreign intelligence authority, they can query a U.S. person's name to view their communications without any further judicial oversight. The Foreign Intelligence Surveillance Court, which oversees these powers, found these queries to be a pattern of widespread and persistent FBI violations. The transition from physical mail to digital data storage created a technical gap, allowing agencies to access content that traditional law did not yet account for. During the most frequent periods of abuse, agents used this foreign intelligence archive as a shortcut for domestic criminal cases, searching the database for evidence that had no connection to national security. The FBI responded to these findings by updating internal procedures. They added an opt-in requirement for agents to access 702 data and mandated supervisor approval for certain sensitive searches. FBI Director Christopher Wray cited these changes as a success, noting internal audits now show a 98% compliance rate with the Bureau's querying standards. However, privacy advocates argue that internal agency policies are easily rewritten or broken. Without statutory consequences, these safeguards depend entirely on the agency's willingness to follow its own rules. This shift replaces clear constitutional protections with agency-level guidelines, leaving the privacy of millions of Americans to be managed by the same officials who use the data. This debate is complicated. The program is highly effective. It is often the primary method for detecting foreign threats before they reach the United States. The government has used Section 702 to identify shipments of fentanyl precursors and to disrupt foreign operatives attempting to plan assassinations on American soil. The reliance on this data is extensive. Over 60% of the intelligence summaries in the President's Daily Brief contain information gathered through Section 702. The intelligence community now relies on a system that produces its most valuable insights from the same database that triggers these domestic privacy concerns. This puts Congress in a difficult position. Lawmakers are hesitant to reform a program intelligence leaders claim is the only thing preventing a major attack. When lawmakers recently attempted to require a judge's warrant for domestic searches, the amendment was defeated by a single vote. The back door remains open. We are left with a fundamental disagreement between the government's pursuit of total national awareness and the citizens' right to digital privacy. If the current system is the only way the government can guarantee security, we have to decide if that safety is worth the loss of our domestic privacy.